Hello and welcome to Context. My name is Enrico Wilford. On this program, we try to put things national, regional, and of course, state and government in context. Today on the program, we have the Minister of Public Security, Minister Khemraj Ramjattan, and Mr. Vincent Alexander, who has a wealth of experience in electoral and constitutional matters. We are looking at the vote of no confidence that was in the Parliament recently in the National Assembly. And Minister, it would be good for us to have a legal position, first of all, on the program. What's the legal position of the government at the moment?
Well, the legal position at the moment, in view of what happened on the 21st, is that the threshold to constitute a no confidence motion would not have been arrived at. We feel, notwithstanding what happened on the 21st, that the numbers of persons who will constitute that threshold of elected parliamentarians is 34 and not 33. There initially was a sentiment, and I'll tell you that very frankly, that there was the thought that it was 33. But after we were, blindsided and by the immoral act, if I may say so, of Mr. Charandas, and we all got betrayed by him when he voted yes. We sought some legal advice. We also went back to the text of the Constitution. We also got a number of authorities that compute this special arrangement that can bring down a democracy, a no confidence motion. And therein we found that indeed it is the calculation, mathematical and juridical, is that it must be half the number of elected members plus one. And if it leads to a fraction, that fraction must be upended towards another whole figure. When we do the calculation of 65, it is 32.5. Plus 1 is 33.5. And then, because of the 0.5, that must go into the next whole number, and it brings it to 34. There are many cases that we have now found that calculate it that way in a number of jurisdictions where prominent judges of their Court of Appeal have done that kind of computation. Now, in view of what happened on the 21st, when the Speaker of the House indicated that he's going to adjourn Parliament to deal with the consequences of that, what one might regard as a surprise, result, in the context of that, we've decided that we are going to argue the case that it has not been a threshold figure that was arrived at. You see, once the threshold figure is arrived at, and we are now arguing it as 34 as against 33, then Article 106 is triggered, meaning that the elections must be held within a 90-day period and so on. That, however, we are saying will have to now be determined by the Speaker, because the internal arrangements of the House is headed by the Speaker. And the Speaker, if there is clearly a mistake in relation to the computation of what the threshold level is, that could be corrected. And that is what we are urging at this point in time, that we are getting up our cases. We are looking at other options. I need not say all the other options that we have here. But the legal position as is presently, and it is now in the public domain to a large extent, whereby a number of commentators on one side of the divide or the other have been making this point. We have some very solid opinions on that matter, and we feel that indeed that is the way to go. Initially, there were statements made by both the President and the Prime Minister, and I thought in the context of that, it necessarily had to follow as a result of what we felt at that point. But in the context now of realizing that obviously a mistake was made and a constitution must not be subverted by a miscalculation or a misstep, it has to be remedied. And that is the position we have taken. A lot of people are saying, but of course, 33 is the majority of 65. But that's not how it is computed in the context of a number of cases that we have. That's the simple way, the simplest of ways that I can expand it here in relation to this matter of what is the legal position. The Parliament has procedures whereby these things can be taken back to it for purposes of remedial action. And this is what we sought to do, and of course, the opening that was created there. On that day, there was the statement, we will look into the consequences of this vote, and the Parliament was adjourned collectively by both opposition and the government side to the 3rd of January. So that's basically the answer to that very simple question.
Which leads me to Mr. Vincent Alexander, because we are in uncharted waters, as Guyanese like to say. And this is really the first time that a no confidence motion has come up in this manner rather. So you can't afford to make a mistake at this point. And you have had experience where, in terms of numbers, there was an attempt to make a mistake. So from that context, I want to ask you, what is the majority and how do we arrive at that majority, both from the electoral point of view and now from the no confidence motion, the vote of the majority of all of the members?
Thank you very much, Enrico. Before I answer your question specifically, I want to make the comment that I've noticed that people are given interpretations of the Constitution. And what I've observed is that their interpretations are purely from a positivist perspective. As if in law, that's the only perspective that one could use. Positive perspective means that they're trying to say this is the letter of the law and that's where it ends. I'm not of the view that legal interpretations necessarily end with the letter of the law, because one can look at legal interpretations from a contextual perspective, as well as one can look at legal interpretations from a historical perspective. And therefore one has to be prepared in the circumstance to see if there is a relevant contextual perspective and if there's a relevant historical perspective. And in that circumstance, one has to interpret based on the literary interpretation in conjunction with the historical and contextual circumstances. And so one would have to see how this law came into being, what were the circumstances about it to being, what was the mischief it was intended to avoid, and on that basis, one can arrive at an interpretation of what the law really means, even before one gets down to the maths of the matter. And this is not something unusual, because legal doctrine is also a source of law, and very often a jurist will take legal doctrine as one of the bases for making the determination of the matter that comes before them. We know, for example, that in the case of the Grenada case, that Chancellor Haynes used legal doctrine. He used normative Kelsey's criteria of law as one of his bases.
The grand norm.
The grand norm for determining that matter. He didn't simply go to what the Constitution provides for. He found a context in legal doctrine which was used. So I think that we have to be careful with persons who are simply holding on to a positivist perspective and not understanding there could be other perspectives that need to be taken into consideration, and that in the constructive interpretation, it is not restricted to merely the letter of the law. One can look at the historical and contextual circumstances. Now, having said that, on the question of what's a majority, one may be able, by analogy, to look at other aspects of our legal system, and in this instance, our electoral system in particular. Because what we find in our electoral system is that the value of a seat is equivalent to the total number of valid votes cast divided by 65. However, on almost every occasion, when you do that, you find in the allocation of seats, there are remainder seats not allocated. And so one has to find a mechanism for the allocation of the remainder seats. And what one does in an attempt to do that is to look for the highest remainder. Which of the parties, after the initial allocation of seats, has the highest remainder, and that highest remainder is then used to allocate seats. And in fact, this has occurred more than once
All
in our elections. There's been attempts, one successful in 2011, to misuse that remainder, and in that instance, the AFC lost the seat to the PPP in Linden. And in 2015, it was that manipulation of the highest remainder that was attempted to give the PPP a majority, when in fact, based on the system we were using, they were not entitled to that majority. So by analogy, one can see here that the issue of highest remainder is relevant insofar as highest remainder tells you about the 0.5 you're talking about, right? When you look at highest remainder, you look to see of the parties, which all of whom may have remainders, you go for the one that has the highest remainder. And on the basis of that highest remainder, which is not equivalent to a seat in the original calculation, that party is then awarded that seat based on the highest remainder. So it's like an analogy, a comparison between 32.5 and how do you arrive at the final number, and allocations of seats with remainders and the highest remainder being used to be equivalent to 1. The highest remainder in terms of absolute votes is less than a seat, but it is used for the purpose of being equivalent to 1 and the allocation of a seat. So it is very similar to 32.5 and taking this, because you can't divide people in half. So in the question of parliamentarians, you have to go to the nearest decimal point. And the nearest decimal point would be if you have 0.5, if you have less than 0.5, you go to the number below. If you have over 0.5, 0.5 and over, you go to the number above. And my understanding of what is being said here is that since they have 32.5, and then the number above will be 33. And so 33 would then become the half, and half plus 1 would be 34.
You know, I've got a good friend for years. He's an attorney at law. And he says this attempt to reinterpret a simple, straightforward provision in the Constitution while proclaiming respect for democracy and the rule of law, when there is an internal parliamentary precedent of the coalition wielding the same 33 majority since 2011, while in opposition, and leaves a bad taste in the mouth. You have a 33% majority.
33-seat majority.
33-seat majority. So what is this discussion on what is a majority? Clear that
Well,
up first.
there's a distinction, because there is an article in our Constitution that says that bills and motions and a whole lot of things can be passed, save and except otherwise provided, by a simple majority of those present and voting. Okay? So if there is a bill, the Narcotics Bill Amendment Bill comes. We have in the Parliament 65 members that are to be seated. Assuming on that day we pass the quorum I think is 22 members, and you had 50 members. Assuming 27 government members vote for the amendment, and the rest don't vote for it, it is passed. You do not necessarily have to have 33 and 32 all the time. We do have that presently in most of our sittings. But once you are present and sitting, whatever is the number that is a majority, that number is what makes it pass. And that is especially provided in 168 of our Constitution. Save and otherwise accepted is Article 106, which talks about a confidence motion. In other countries, it is called a no confidence motion. And it has a special majority of the members there. It says a simple majority, a majority of all the elected members of Parliament. Now, what's this, all the elected members of parliament? A majority of all the elected members of parliament. All the elected members of parliament means 65. Okay? And I'm going to give you a significant example just now to show how what I'm talking about, what could have avoided this. Now, assuming half of that 65 comes up to 32.5, the juridical thing is that you do not have 0.5 of a human being. It must go to the next whole number. And since in the computation, juridically, it is plus 1 of that half, it will be 33 plus 1. So although you can mathematically or arithmetically say, well, 33 is above 32, and that's the end of the matter, not so. When a democracy can be subverted in that way by calculating it thus, and only just having one man changing and calling for elections and all of that. And the cases that I'm talking about, explain it in that way. And no confidence or a confidence motion is a different motion above all else as the Constitution made mention. Because Article 168 make it quite clear. I've walked to the Constitution here because a lot of people, save as otherwise provided in this Constitution. All questions proposed for decision shall be determined by a majority of the votes of the members present and voting. Now, save and otherwise provided by the Constitution saves Article 106, which says that by the vote of a majority of all elected members of the National Assembly. And there is where the distinction is. Otherwise, we can say that on if we wanted all motions, including confidence motions, to be 33, okay? We need not have put this inside. We could have deleted that. And go back to 168 and say, determined by a majority of the votes of all members present and voting. But it is because it was saved a special arrangement for no confidence motion. And when the drafters of this Constitution obviously were drafting it, I rather suppose they had, or the experts that drafted it, they had in regard the existing law being that it is half plus 1, and when it leads to a fraction, it goes to the whole. And that is why this is in here. It is important that people just do not follow through with what is regarded as this simplicity. The law is the law, and that is why the Constitution made an exception to 168 by having 168 drafted the way it is, and also now save and accept this 1066. And so the friend that you have there obviously must know this. Again, we had a situation whereby we had a voter ID. We never had before, under our Constitution, the need for voter ID. And although all the parties agreed to voter ID, it was held to be illegal. And a new government had to be put in place within a certain time, right? And so this addresses this question that there are interpretations that must deal with the questions of the context of the Constitution, not the text of it alone. Context is important. Why then would they have said, save and accept as provided in this Constitution in other places, and then have it like that?
I'm going to go to Vincent once again, Minister Khemraj. The issue of the majority, again, is people are saying to me, oh, come on, in 1979, Margaret Thatcher was able to oust James Callaghan, if you guys recall, by one vote. How is it, and I think it was 310, 311, how is it that can't happen now? And then they also refer to the Vanuatu case, where they're saying, well, look, the Vanuatu case was an even number. So a majority had to be
plus 1.
Yeah, 27 plus 1.
Right.
But because it was an even number.
Yeah.
Vincent, explain that to us.
Well, I think it's interesting to note that there's a difference between a circumstance where the number is even and a circumstance where the number is not even.
Yeah.
And I think the issue we're faced with is that the number of 65 is not even. And the mathematical logic of arriving at what's a majority takes us to 34. That's the reality that one has to deal with. No, but I want to make another point in response to your friend. I think that there could be a range of views in this matter. But I think at the end of the day, we have to respect the fact that it is the court system that makes the final determination on such matters. And that there's absolutely nothing wrong in an affected party asking the court to make that determination. And so though you may have a view on the matter, you should also respect the fact that you can't castigate the views of others to the rubbish bin in the face of a system which says, here is the authority to make the determination. And therefore, if this matter ends up in court, that is where the determination will finally be made, because that is where our law is finally defined. And that's what we have to live with.
Just like in the case of the third term. I mean, the intent and everything was there. 2 terms and no more. And then it was carried to court, obviously by the opposition leader acting through the instrumentality of a Cedric Richardson, to ensure that there can be more, and that thing is the prescription there was unconstitutional. So it is not necessarily what we say, it is largely what, how we argue it and how we feel that the court will pronounce on it. And that is why, I mean, you have a situation whereby almost everything we did, Mr. Nandalal would go to court with, okay, because he wants what is called a final, absolute kind of determination, because the courts do bring finality to it. But this is very, very clear. Let me give the example. I almost missed it. In this kind of arrangement of Article 106, whereby you must have a majority of, say, the all elected members, you know, come to think of it now, a very smart person indicated to us, had we taken out all our 33 members from that parliament that night and go and have a meeting somewhere else, and the PPP were to vote, and they voted 32, okay? And the other side vote, and there is no vote, 32-0, it would not have passed. Do you understand what I'm saying? Because it did not have a majority, as we are saying. We are now saying that it is, but they would have only had 32. So in the context of what it is, although it is a 32-0 vote, a 32-0 vote, it says you have to have a majority of all the elected members of the parliament. So I want to bring that mathematical arrangement to people, because a lot of people say, oh God, they got 0 on one side and 32 on the other side. It should have passed. But to give meaning to this special exception, save as otherwise provided for, gives that kind of special meaning to Article 106.6, to the extent then that what then is the special majority? It is something other than the simple majority of a 168 Senate. And that is why a lot of people don't want to make that distinction. Because you have a scenario where the Constitution is making an exemption of a special majority for a no confidence motion. And when you go and read the jurisprudence on no confidence, it says that this kind of thing, around 8 times it happened in Canada, where no confidence was done to that extent, that it brought down government, the Harper government, the Ling Ping government, a number of, I can't recall all the names of the government, but it brought a lot of crisis in the country. And then the jurisprudence indicated that you must be clear about the majority. And there must be fractions. It has got to be very, very clear. There is a South African case, there is a very much square-on Kenyan case in the point, and so on.
But surely, if the Constitution wanted to be clear, it would have said, like the Vanuatu Constitution, an absolute majority. And it doesn't say that. So
No. An absolute majority cannot be anything dissimilar from a majority of all the elected members when the jurisprudence is saying whole numbers must go. Absolute doesn't mean that you're going to go to whole numbers. A majority is a majority. What is a majority? A majority is half plus 1. And when you get a fraction, it goes to the whole. And that is the simple nature of the thing. You can't now go and describe the majority as absolute and then only round it off. Because And by the way, a very popular judge had to make a determination of this matter, Adrian Saunders, when he was a High Court judge in one of the Caribbean countries in a matter in Anguilla. And he determined, although it is applicable for, in that case, the quorum question, it is clear that in fractions you have to round upwards. Take, for example, our quorum says 1/3. 1/3 of our parliament make up a quorum. Otherwise, you can't start the parliament.
It's 21 point something.
It's 21 point something. And what is the ruling in it? It is 22. It is 22 because you round it up next to the next whole, not bring it downwards to the 21. And so that is clearly, that is why 22 is our parliamentary quorum. Why is it that? Because it's 21 point something or 21.6. For 1/3 of 65 is 21.6, whatever else. 21.6. Now 21.6, what does that mean? It means 22. You do not have 22 elected members in Parliament. Parliament can go on. Not 21. And that was the kind of case that Adrian Saunders had to decide in Anguilla. And so on. And then he made that. Now that man is a reputable judge that has gone to be the president of the CCJ. You understand? And so we are saying that. Moreover, as I said, a lot of other cases, authorities in the Commonwealth and also non-Commonwealth countries where this no confidence motion is clearly delineated as to how to calculate it in relation to when it's that close.
Minister, we are coming up to the half an hour point on the program, and I know Mr. Vincent Alexander has to bow out at a certain point in this program, but I want to put a point to Vincent right here with regard to how the constituency system is, who's representing the list, and whether it's like a seesaw. Once you lose a seat, it slides over to the other side and it changes the balance of power.
Well, I think that we have to look at our electoral system, and again, from that electoral system, see what's the morality that we face with. Whilst it is true that we have constituencies, and our country is divided into constituencies, our electoral system is essentially a proportional representation system. When the electorate goes to vote in Guyana, for all intents and purposes, even in the instance where we have constituencies, they vote for the party, they don't vote for an individual candidate. Because even where we have constituencies, they are multi-member constituencies. And the party reserves the right at the end of the election to determine which of the candidates fills the seat that's allocated to the party. So what I'm saying is that in every instance, you vote essentially for the party. You don't vote for the individual candidate. And that raises a moral question. The individual candidate, therefore, for all intents and purposes, is elected at the behest of the party, insofar as the people do not directly say, this is the candidate I want. People say, this is the party I want, and I'll accept the party's candidate. So to me, that creates a situation of collective responsibility. It does not allow morally for someone who is elected at the behest of a collective to use the privilege of being a member of that collective to bring down the collective. It's highly immoral. And so our system, for all intents and purposes, does not facilitate a situation where an individual can claim to be representing a constituency and therefore have the freedom of exercising a vote. So if you go to other systems, like the British system, for example, where they have constituencies, that MP is directly elected by the people. And in fact, in some of those countries, the MP can be recalled by the people as well. In our system, the recall is by the party. So again, we see, if you look at the law from a holistic perspective, that the law bequeaths the authority to the party and not to the individual. And so when the individual to get up and say, look, I'm voted my conscience. If a person has a problem of conscience, the problem has to be with the party, and what that person ought to be doing is to resign from and leave that collective with which he has a problem, but not use that vote to impose upon the collective a determination when he's a guest of the collective. And here is where I think we have a serious moral question in terms of the behavior of Mr. Charandas.
Thank you very much, Vincent Alexander. You're with the program Context on NCN. We're looking at the issue of the no confidence vote. When we return in just a moment, we'll be continuing the discussion with Minister Khemraj Ramjattan. We'll be back in just a moment. Hello, we are back on the program Context, and we are discussing the no confidence motion and what happened in the Parliament. I'm with Minister Khemraj Ramjattan. He is the Minister of Public Security, but he's been looking at the legal aspect as we look at this issue that is basically uncharted waters. With regard to the majority, we were talking earlier on with Mr. Vincent Alexander, but the whole idea of a simple majority versus an absolute majority, there seems to be some confusion, or there seems to be some conflation in people's minds that, look, the government already has a majority. How come again there's a majority for the government and yet there's a majority for the no confidence motion? Yeah. Is there confusion, or is this, are they conflating the two things?
There is a distinction that has to be made. You just can't conflate the two things. A majority for purposes of passing all the other motions and bills and other whatever the Parliament has to decide is a simple majority of those present and voting. And if every member is inside of that Parliament, it will have to be a 33-32. Okay? That's what the majority there mean, because if it was present and voting is what now makes that clear. Where, however, it is a majority of the elected members, as I have seen, and then we're going to repeat this, it has to be, because when you are present and voting there, you could distinguish the 33 from the 32, right? Just like if you didn't have a full house, let's say you have 60 members instead of the 65, you can distinguish the majority as against the minority. When, however, and that is why the no confidence and a confidence motion got this thing specially exempted from that 168, because I think that is what a lot of people don't understand, that it is specially exempted out of 168. It is not from those who are voting and present in Parliament or present and voting, so that you could know that that's a human being. That is 33 human beings as against 32 human beings. But assuming that we had all walked out of the Parliament, all 33, including Charandas, who did the betrayal, the PPP would have only gotten 32 votes. And that does not mean that 32 against 0 means that the no confidence motion passed. You understand what I'm saying? So there is a distinction there to be made, so that to give this exemption a special meaning. It is a special prescription under the Constitution. And there is a jurisprudential way that you handle that, like Adrian Saunders did. Take, for example, the 2/3 majority that is now needed to extend the time, assuming it is 33. We are arguing it's 34, but assuming it is 33, we now can go and extend the 3 months period for an elections with a 2/3 majority. What is a 2/3 majority of the Parliament? 2/3 majority is, I think, 43 point something, 43.5. But the 2/3 majority, assuming only 43 people vote for that extension, it is not reaching the threshold mark on the 106.7. It has to be the whole number rounded up. That is what happened in the Anguilla situation. You have to have 44 members to constitute 2/3 of the Parliament, so that you can, elected members of the Parliament, so you can then proceed with an extension of Parliament. And so So it is not a simplistic thing whereby you're going to say that because all the other bills were passed, all the other motions were passed by 32 scenario, that necessarily follows. This has its special role, and it is a role that brings down a government. You'll have to have now a whole lot of things going.
But can you import words into, is it 106? Because as I said earlier on the program, absolute is not in there.
No.
But it would appear as if the government wants to import the word absolute in there.
No. When the Constitution is made, a Constitution is made with a lot of laws existing. Laws existing and words have meanings. You go to the legal dictionary, you know what is a majority. Majority has a special meaning. And a majority is half, direct half, plus one. And when it is a half and a fraction, jurisprudence all across the country from even before indicates that you must round it off. And so it is not as if we are importing words. When we are dealing with Constitution, a document that is, how much pages? 245, 246 pages. That cannot cater for all the unforeseen circumstances. It cannot. It does not specifically state that it must be 44. It could have been done that way, however, it was not done. So what do? You go back now to the evolution of the jurisprudence in the question. And when we go back to the jurisprudence evolution, we come to the realization that this is how it is done.
But another attorney is saying that half appears in other parts of the Constitution when you're talking about votes. And the fact that half does not appear in this part means it wasn't intended to be in there.
Well, it very well can be so decided by a court of law, but the trouble is, I believe that it cannot so be decided, and that is why you might have even judges. Some judges will want to say, no, that is not the thing. Another will say, yes, you carry to the Court of Appeal. Remember the two terms case? You had the High Court, Ian Chang, saying, yes, that is unconstitutional. You had the Court of Appeal with Carl Singh and the rest saying it is unconstitutional. And then you carry to the highest court and there is a ruling. On highest courts in all the cases that I have now learned, they have ruled that that's the way you do it. And that is why a bright judge, and so bright judge like Adrian Saunders have done it. And, you know, we can carry on because there will be argument. You know, in a legal group, if you got 10 lawyers, you can get 10 different legal opinions on the question. And that is how it is. But when you start asking, well, bring your authorities in the matter. What is the jurisprudence? What is the juridical reasoning that carried you there, and so on? Then, he says, this is not mathematics. 2 and 2 sometimes, if you ask an accountant, he will tell you that the bloody thing is 22. It is not 4. And depending, but quite frankly, that's being facetious. The trouble here is that in view of what we now know to be the position, we are arguing that.
Another argument that I'm hearing with regard to 106 is that 106 refers to vote in a singular manner, the vote of the majority. And 106,
yes,
I think,
right, yeah,
refers to it,
the vote of a majority.
Of
a majority.
Yeah. But the other one that you're mentioning, talks about the votes.
By a majority of the votes. Of the members.
And therefore, the vote of the majority must be seen as one collective, as one thing. So the vote of the majority is seen as half plus 1. Because it refers to the whole, the entire majority.
No, well, that is why the constitutional framework says those present and voting, the votes of those present and voting. Because
which makes these individual votes as against a collective.
As against the collective, and that is what this is talking about. Mm-hmm. What is a majority in accordance with the law of a collective? It is 34. Whereas you can easily know a majority of 3, 2 and 1. When you're voting, present members and voting. But when it is a majority in relation to all the elected members, it is a completely different thing. And that is why. It looks as if it is laughable A lot of people might want to say, but we're joking here. It is not. These are serious legal issues that have to be determined by the jurisprudence and the reasoning that goes along with it.
Minister, you know, some people are making jokes on social media with regard to mathematics and what have you. But somebody who I understand to be a pretty good mathematician said to me, put it another way. As long as you have an even number of seats, you must have an odd number to constitute a majority. That is more than half. And as long as you have an even number, it must be an odd number to constitute a majority. And to my mind, that is a simple and straightforward thing. So if you have 65 people, the number must be an even number. It must be 34. If you have 52 people, the number must be 27. It must be an odd number. But again, why is it so difficult for people to understand that the plus one thing? Why
this is a polarized country, Enrico. You go to any person now, and even on matters like when the third term, what should be the third term? We were clear. The constitutional intent was to have a scenario like in America. 2 terms and you go. Barry Jagdeo, however, got a portion of Janet Jagan's term, so he get 2.5 terms. And like he don't even want to go up to now, you know. So this is a polarized system. So the reasoning of, let's say, those lawyers that are saying it is 33, the members of the Bar Executive, because that's not the Bar Association in my view. I hold it because lots of the bar members have told me they are not with that view of what the Bar Executive recently come out with. And you can say that it is prejudiced and all of that. I'm not going to go there. The trouble, however, is that because we are so polarized, half of the country is now going to make the point that say, though, if I do that calculation and say it's 34, I'm really supporting APNU AFC. I do the calculation supporting 33, I am a supporter of the PPP. And largely that is what is happening in this country. We would like to have a country that goes back to the jurisprudence. What is the legal reasoning? Because if we want to be rule of law, we have to go back there. And if indeed when we go back there and the thing proves like the brilliance of Adrian Saunders calculating it the way it is supposed to be done, oh gosh, well, I'm arguing against myself because I'm arguing against the PVP. And so I don't want to go there. And that is what is making people not understanding or wanting to understand it. And so we are going to get that. And that is why, quite frankly, in the chaotic scenario of a democracy, which we have here, you will have that. You will have that all across the Western democracies. The Brexit vote, the Donald Trump kind of vote, all manner of things. Society is very polarized, and sometimes it is polarized by tribes, tribalized politics. And we have a large amount of that in Guyana. So no matter what, if you get the best lawyer to tell you that this is how it should be calculated, some people out there who says, well, that is against the PVP, oh my goodness, that can't be right, because that is the ends is what justify, you know, that this is how it should be calculated.
But Minister, the now government was in the opposition at one point, and you accepted it as I said earlier. Therefore, was it a mistake then?
It was, look, let me be very frank with you. When our AFC put up that no confidence motion, I tell you honestly, I thought it was 33. And I am well aware now that the then Attorney General, Anil Nandalal, asked for a legal opinion from a very prominent counsel. And that prominent counsel told him, because that counsel and his chambers was asked to determine the matter, they came up with 34 after all of these cases they reviewed, which has now been brought to our attention now. Okay? So that is it. The then Attorney General, however, did not bother with 34. Although we had felt it was 33, he was told it is 34. He did not. I understand now that he didn't do it because they wanted that term to be cut short, probably because he had selfish interest in furthering his presidential candidacy. Because you do away with the Ramutar in just 2 years, you get another elections, bam, you might very well be the next presidential candidate. He probably didn't realize that Dana Ramutar won't run back, and he ran back. But I don't know if he ever gave Donald Ramotar that legal opinion. I think Donald should ask him about that legal opinion and all these cases now that we have. Why is it that you allow my term to be cut short? Now, in all honesty, we didn't put it to a test then because they prorogue Parliament. They close up Parliament and gone and prorogue it and then dissolve it and had the elections. So we never went to a vote of no confidence at that point in time. But in any event, there was a legal opinion before with the Attorney General, and he, in his own mind, or probably with Barrett Jagdeo, because I understand that is where he goes all the time. For how do we move now that we got a legal opinion that it is 34? How do we move? And he probably was told, keep it quiet. Don't bother with this 34 thing. I don't think it is right, whatever. And then he didn't probably tell his president. The trouble is, whatever transpired then for whatever selfish motives or a grand, legal opinions saying that this thing 34 is not right, whatever happened then, I was unaware of it. Now I am knowing of it and also knowing of the cases all across the place. And that is true. That is a fact because we felt that we could have moved them with a 33. It didn't happen. But that is not being hypocritical. If you now know and you read the things, it is quite clear that it is 34, as I've said. And we're going to give it a shot to that extent. We're going to bring it to the attention of the Speaker who was asked that the consequences be determined on that next day. And so we will see how it goes. That's one of the options that we will be taking.
What's a parliamentary procedure to correct the first wrong?
The first wrong could be corrected by telling the Speaker that the law as it is now, clearly, is not 33. Assuming for some reason, let's say a quorum was not known, and that he didn't know about the Adrian Saunders case and things like that, and he had said 21.6, that means 21 instead of 22, and a parliamentary session had gone on there, and then somebody next session say, you know what, there is a mistake that was made there with the quorum. We should not have had Parliament for the 21. We should have had it for the 22. All right, then everything that went on there would have been ruled now by the Speaker. It could very well be ruled that we're not going to have that. Or you can have a validation of all the members now in a genuinely quorumed collegiate, stating that, okay, we validate what happened there notwithstanding. You can do that too. A validation by the next meeting, just like in laws of meetings. Okay, there are certain decisions were taken, and that can be a validation process.
Is this delaying the process at all, Minister, as we look at the issue on this program context, that the government just doesn't want to resign as required once there's a vote of no confidence?
Absolutely not. It is not that we just don't want to resign. If indeed a final ruling is made that the law is that it is 33, and that our final court or whatever says that, we certainly will respect the rule of law. But when this was done, and because of what Sharon Das' betrayal did and constituted, a total surprise to us all here, we have to remedy the situation. Our constituents, those people that voted for us, would say, but why didn't you give it a shot? First of all, at the Speaker to correct himself, or the internal arrangements of the House to correct itself, or go to court to correct ourselves? Why not? So it is not delaying. It is about having clarity. And that's how democracies develop. Because if it were now to happen in 2020 or 2025 or whenever, people will learn and say, well, here, we have a ruling now. In 2018, this happened. And we will learn and take it from there. So we are preparing good, fertile ground for the education, jurisprudential education of what happens in a scenario like this, so that mistake will not be made and so on. So it is important. And a final ruling, and we abide by that. It is the first time that this has happened, and so it is not with a nasty political motive. Obviously, there was a nasty political motive when Sharon Das did what he did, because we are now learning that there was absolutely a connection with bribery of some big sum of money. We are getting, the police are closing in on the case, okay? So it is important. Sharon is not a hero. Sharon is a villain. I am saying so from the evidence that we are now getting. So everybody out there must understand that. And we are getting a good beating and all kind of thing because of the fact that he has come out and said that it was his conscience. Here is a man that all through the months and the years he was with us never complained. I felt so blindsided by what he did. And it is obviously he was compromised with very big sum of money, which I understand now he had wanted to transfer overseas and all of that. So we are getting it. He sold his car. We didn't pay attention. Well, we could be beaten for that. But then we are living in a democracy. If Enrico wants to sell his car, BMW car, to a friend of his, you don't read too much into that. But now the evidence is coming out and more information is coming out. This fella was compromised financially. And that is why he never wanted to abstain from, let's say, a vote, because of the consideration of that pecuniary advantage. He then decided to do it exactly on the no confidence motion.
But you must have irrefutable evidence that this has happened. You can't just get up and
No.
make an allegation.
We are having it because he has spoken to people and all kind of thing. And this is what we are now tailing into. It is clearly a case where he is compromised. And obviously, those who moved the motion, or at least one person that moved the motion, knew about this. He knew that they had Sharon Das in the bag. Now, that is not the kind of democratic practices we want for this country. You had to know that you got somebody in the bag.
And you ought to know that too.
Well, we did not. We knew that this fellow come with a lot of things and all manner of things for the relevance of him as the opposition leader. And of course, you ask very many members who a lot of people were saying X, Y, and Z about, and fine, they said no. But the next question has to be, is that how we must do our democratic practices? Should we pay somebody out and then he cover it up with a conscience? He always criticized on the the TV show that we have in Berbice, how the PPP government is the one that bring the sugar industry down. He was doing that long before. That is why we were attracted and felt him appealing to come on board with us. He was genuinely constructive and saying that the PPP was the bad one. All of a sudden, everything upturned, obviously because of that kind of a compromise. So I am saying that this is not how we must have our democratic politics in Guyana.
Minister, we have about 2 or 3 minutes more left in this program. Whether you like it or not, the country will face an election either within 90 days or sometime soon thereafter. By next year,
Well, I am not so
things are
certain about that.
supposed-
I am confident that, okay, but
I want to ask you how confident you are in terms of the preparation for elections.
Very in preparation.
Yeah.
In relation to GCOM, well,
Not GCOM related to the government.
I feel that we are very strong on the ground in view of what will transpire here. You will have, when it is now known, and a lot of people are now knowing that what Sharon Das did, he himself in Canada saying, so what if I take a bribe? What if I take a bribe? Okay, because obviously he knows that it is coming down. Now, when people know that that is what was done, and then by who? Because somebody brought the no confidence motion knowing that that happened, this country is going to be turned around. And those who are now yapping in triumphalism, they are going to get the worst of it as a result. So look, it hit us, blindsided us, whatever, but it is going to come back, and a wave of support for us. Because let me tell you this, Enrico, we have tried as best to be democratic all along. That same night in the Parliament, I went up, I realized that if any harm was to be done to Sharon Das, an Indian that crossed over like that, you can have civil strife in Annandale, then it could go on to Buxton, then it could go. You please, hold on, police. What, you want security? Yes, I want security. Bring the thing and give him the security. You had to do that. We had to say, well, fine, this is it. In the context of what we didn't know then, we are going to deal with the consequences on the next day and all of that. To bring tranquility and calm and law and order. Of course, he didn't take my security arrangements because a fella, I think Peter Ramsroop, told him in his ears, the police gonna kill you, ass. You better take we own. And I didn't know that Sean Hines and a couple of other fellas were already there at the back in a car waiting for him. This thing was organized beautifully. And we got caught. So that is what I'm saying. With all that will come out as a result of the investigations going on, we are going to benefit from it because Guyanese don't want those kinds of politics in Guyana anymore. We do not want it. Where you're going to buy off a man like that. That is democracy. And then we got to get to find out who was it that paid that big set of money. And we are going to go very far and deep into it. And those who would have done that, they will pay the penalty. We have already started doing investigations of senior members of the government. Very valid investigations. They want to say that we are politically motivated. We are not. The president, the prime minister, the entire cabinet want genuine political practices in this country. And what we saw there is absolutely ludicrous and to an extent illegal, illegitimate. And we are going to benefit from that.
Thank you so much, Minister Ramjattan. Minister Ramjattan was appearing on the program Context, in which we were looking at the whole issue of the no confidence vote and what the government's position is. Thank you so much for joining us. I'm Enrico Wilford. Goodbye for now.